Good afternoon. I am Jocelyn Benson. I'm the Dean of the Law School here. I want to welcome you to Wayne Law and to our annual Goodman Cohen Lecture in Trial Advocacy. I always enjoy this annual event because it is such an important issue for all of us here at Wayne Law. So important for our students to reflect upon and learn the skills of trial advocacy while you're here, for us to talk about all the important information that comes out of this lecture series. For 30 years, the family of the late Goodman Cohen has brought this lecture series to Wayne Law, and in turn, we're proud to carry on his tremendous legacy in this area. He was an active member of the Michigan Trial Lawyers Association, which is now the Michigan Association for Justice. And Goodman Cohen was a fearless advocate for equal and fair application of the law, which are principles that we seek to instill in our students, the next generation of Goodman Cohen's other prominent attorneys for years to come. So we are here at Wayne Law incredibly proud to be home to this informative lecture series, and I do want to recognize Cohen for joining us today, and thank you for your support of this important series. Today we are pleased to be joined by Judge Joan Young, who is an alum, class of 74, and the Sixth Circuit. She's currently a judge on the Sixth Circuit Court in Oakland County, and Judge Young will deliver a lecture on the topic of oral advocacy and pretrial practice. We have as well with us today a good friend and alum, Dean Googasian, class of 97, of the Googasian Law Firm, and Moneka Sanford as well, class of 2003, and also in the law offices of Moneka Sanford. Thank you both for being here and facilitating these commentators today. And I'm now happy to introduce Professor Bob Sedler. Bob Sedler is a living legend here at Wayne Law. He's a distinguished professor and has organized this event for many years. He's litigated a large number of civil rights and civil liberties cases. Any of you who've been fortunate enough to have him as a professor know how valuable it is to have his real-life experiences in the courtroom shared with you every day, and as you learn constitutional law with him. And in addition to, of course, being a professor here, he's a volunteer lawyer for the ACLU. He served as a member of the Social Action Commission of the Union for Reform Judaism, and is also, or has held the Gibbs Chair in Civil Rights for Civil Liberties here at the law school. Professor Sedler.
Thank you very much. One of the pleasurable tasks for me for many years now is for organizing the Goodman Cohen Lecture. Usually we bring in somebody from the outside or a local and have an evening program. This year we have changed it. We are having the lecture in the afternoon, oriented toward our students and oriented to the work that lawyers do in pre-trial. You know, you learn law from appellate cases, we know about trials, but practicing lawyers will tell you that what we do, what lawyers do mostly, is before cases ever come to trial, and most of them don't. It is a great pleasure to present a lecture, a talk, I should say, by Judge Joan Young, who has been on the Sixth Circuit for a number of years, since until since March 1997. She's been on the Sixth Circuit. She has been Chief Judge. She has very much involved with the Adult Treatment Court. She will tell you much about her work. Dean Googasian is one of our alumni. One of the great thrills for me, for other alumni, are people who have been former students. Dean is the class of 1997 with the Googasian law firm. He does a good deal of personal injury and other work, and I'm not going to go into a longer speech because you want to hear the program. And I must say about Moneka, Moneka is, in addition to being a lawyer, a social worker and an ordained minister. And so she gives truly her clients the perspective that comes. She's going to talk from the standpoint of criminal law. She has been the defense attorney for the Oakland County Juvenile Drug Court program. So we're going to have the judge talk for a while. We're going to have Dean and Moneka comment. Then we hope to have some time for questions. Those of you that have a class at 1:25 1:45, have to go to class, but we will end the formal part of the program by 1:20. We're on time, and now it begins my great pleasure to introduce Judge Joan.
Thank you so much. Welcome to everyone to the 30th Annual I. Goodman Cohen Lecture and Trial Advocacy. I'm delighted to participate in this event, especially since Ina Cohen, my friend and law school classmate, and daughter of the sponsor of these lectures, thought enough of me to include me in participating today. Thank you, Ina, and thank you for being here today. Joining me today are two distinguished graduates of Wayne Law School who will address issues pertinent to their area of expertise. Dean Googasian is an expert in civil litigation, and Moneka Sanford is an experienced criminal law litigator. I hope our comments today will provide you with important insight into the practitioner's approach to civil, criminal, and family law. And if it wasn't mentioned before, that is my area. Since 1998, when the family court was established in Michigan, I have been a judge of that court in Oakland County. As an overview, I wanted to give you just a few facts. Before I was elected judge, I was the circuit court administrator in Oakland County. I spent a lot of time with numbers, statistics, and data, and I've never really recovered. I will start by saying that most cases are resolved short of trial. How many of you think that 50% of all of the cases filed go to trial? Anybody? How many, and by that I mean either bench trial or a jury trial, either one. And how many of you think that maybe a third of the cases filed go to trial? Nobody. Somebody's been here telling me my secret right out here. How many of you think that 20% of all the cases filed go to trial? Well, you'd be right. The actual numbers differ depending on the case type, but they're much lower than one might think, and maybe lower than you actually had in your mind. In 2013, and the reason I'm using 2013 statistics is that they have not yet published the 2014 statistics, but I doubt that they'll be significantly different. There were 3,899 capital crimes disposed of statewide. 17% were tried. In Oakland County, 16% went to trial. Of the 53,224 non-capital crimes disposed of, only 2% were tried. And in Oakland County, only 1%. In civil actions, there were 46,404 cases disposed of in 2013. Only 641 were disposed of by a trial. That's 1.3%. And in Oakland County, of the 6,985 cases resolved, only 68%, or 68, went to trial, and that's less than 1%. Now, in my area, of the 43,610 divorce cases disposed of in this state, 529, or just a little over 1%, were tried. In Oakland County, there were 4,926 divorce cases resolved, but only 42, less than 1%, were tried. Now remember, there's no jury trial in divorce cases, so all of the cases are tried to a judge. However, let me point out that in family court, the judgment is not the end of things. There are many post-judgment hearings for custody cases, support modification, and other issues related to children and enforcement of court orders. No one keeps an accurate count of all of these matters, so I can't give you any reliable data. However, my observations and comments about pretrial procedures and oral advocacy apply with equal importance to these post-judgment issues. Now let me turn to a brief discussion about the importance of pretrial procedures in family law cases. If so few cases are actually decided by a judge, how do they get resolved? I cannot emphasize enough the importance of investigation and preparation. Some practitioners feel that because Michigan is a no-fault divorce state, that divorce cases are easy. Nothing could be further from the truth. While it's not necessary to prove fault in order to get the divorce. Well, maybe a factor the court can consider in custody, support, and division of property. There are a couple of other features of divorce cases that are unique to this area of the law. These are very emotionally driven cases. That's not to suggest that civil and criminal cases lack an emotional aspect to the process. But remember, in divorce cases, the plaintiff and defendant were married to one another. At one time, they professed to love one another and plan to spend their lives together. We see them after that love has turned to hate or indifference. The parties may feel betrayed, demeaned, or rejected. And these are strong emotions that are difficult to control. Now, the parties may have children together, and regardless of whether the children are minors at the time of the divorce or have reached majority, the children will keep the parties tied together for the rest of their lives. They cannot simply walk away from each other at the end of the case. They will share graduations, marriages, grandchildren, and other sorts of things. And sadly, the children are often the real losers in the divorce. They have had no control over who their parents were, no control over the decision to divorce, and are often the pawns used by the parents to avenge the anger they feel. Sometimes judges will appoint a guardian ad litem for the children to protect their interests. Now, this costs money. And speaking of money, generally, all of the money used to pay attorney fees and any other costs associated with the litigation will come from one or both of the parties' assets. Thus, whatever the lawyer gets paid reduces the pot to be divided between the parties. Not surprisingly, litigants can turn on their lawyers when the case is over. I've heard horror stories about attorneys who lost their fees after the divorce because their client filed for bankruptcy. Divorce cases are generally resolved within 1 year of the filing. That's a little longer than a criminal case and less time than it takes to resolve a civil case. The time may sound like a long period, but there's really a lot to do, and it requires prompt attention to the pretrial process. Discovery is the key part of the pretrial process. What do the parties own that is subject to division? What do they owe? And how discovery should be conducted discovery should be conducted with common sense. Once, years ago, I had an attorney come into court complaining about the interrogatories that had been served on her by opposing counsel. It was an overwhelming number of interrogatories, and she felt that was really unnecessarily burdensome. The sending attorney was attempting to justify the huge number of questions asked, but the complaining attorney waved them in my face and said, "Judge, just look at this. He's labeled them harassing interrogatories." Sure enough, his secretary had typed harassing interrogatories in the entitlement of the papers. True story. Now, apparently he had a file that he used for cases where maybe he didn't go along with the other side, or maybe he thought it was a particularly difficult party, and he labeled them in his office harassing interrogatories. But apparently the new secretary didn't know she wasn't supposed to type the word harassing. Much can be learned by asking the right questions and asking for specific documentation, but it is important to remember that there's a deadline imposed by court rules by which the receiving party must answer. Attorneys make a critical mistake by failing to timely object to discovery questions or responding appropriately. However, the sending party cannot complain just because he or she doesn't like the answer. "Judge, his answers were all lies." Well, I guess you'll have to prove that. Often a party must subpoena documents from outside entities, such as banks, just to prove that. Prompt action is required to get documents in time for settlement negotiations or trial. After an exchange of interrogatories, attorneys may depose the litigants. This should be done sparingly. Again, be reminded that the cost of all that is done is borne by the parties. The most economical and efficient discovery is done by attorneys who, while representing opposing parties, get together, exchange information, and draft a joint asset list. Lawyers in divorce cases also should not hesitate to use experts to assist in understanding the value of assets. Real estate appraisers, business evaluators, and certified public accountants are among the experts who are best able to assist attorneys in understanding the assets and how they may be divided. If possible, using joint experts can speed the process and save money. Experts may also be helpful in resolving issues involving children. Some psychologists can provide useful evaluations of the children's needs and the parents' ability to meet those needs. If the parties are children or children are in therapy, those mental health providers may provide important insights into the needs of the children. However, caution must be exercised by attorneys not to unwittingly agree to waive their client's privilege against disclosure of private information. Once sufficient information about the assets of the parties and the custodial needs of the children are gathered, the case is ready for mediation. Most judges require mediation, and after I wrote this, I thought, well, I really can't say that. I know that in the metropolitan area, most judges require mediation. I don't know if that's true in all jurisdictions throughout the state. But there is a caution. If domestic violence is alleged, mediation may not be appropriate. Even with such an allegation, some mediators arrange their sessions so that the abused spouse is not in direct contact with the alleged abuser. This is an opportunity for the parties and counsel to sit down with a trained mediator, usually a lawyer, but not always, and discuss possible resolution of the case. A significant number of cases are resolved in this way. The parties may spend many hours over 1 or more days in negotiations. Ultimately, if an agreement is reached, it will be reduced to writing and signed by the parties or placed on recording with the parties' concurrence. Once done, this agreement is almost impossible to change. Second thoughts or discussions with a know-it-all neighbor or a friend will not permit the judge to set it aside. Now, some cases are referred to arbitration by agreement of the parties, and I would point out that arbitration is something the parties must agree to. No record is required except as to support custody and parenting time decisions. Arbitrators are also generally lawyers. Arbitration allows the parties to present their case in a much less formal and non-public environment than otherwise would be the case if they were in a courtroom, which is a public environment. Because there is no record except as to support custody and parenting time, there's almost no opportunity to appeal. Once the arbitrator's award is confirmed by the court and incorporated into a judgment, it is as enforceable as any decision made by a judge or agreement made by the parties. Good lawyers, and I'm sure you all are and will be, can settle cases without either mediation or arbitration. However, you may not have good lawyers on both sides, or you may have some very complex issues involving property or children, so dispute resolution methods such as these are a common method of settling the case. If all else fails, you can present your case to the judge for a ruling, and that, of course, you can appeal. And some do. I don't know why, but they do. If all else fails, as a family court judge, I generally see a problem case early on in motion call. Demands for support, parenting time arrangements, unfulfilled discovery requests are common issues that get addressed on motion day. Unlike civil cases, attorneys in family court show up with their clients in tow. This can be good as it provides another opportunity for everyone to sit down and talk about a resolution. It can be bad if the advocacy results in ratcheting up the conflict. A regular motion call, at least in Oakland County, will have anywhere from 30 to 50 cases scheduled for hearing. Therefore, time is extremely important. Motions should be clear and straightforward. What do you want and why should I give it to you? Allegations in a motion should address only the issues presented. Attorneys too often start off their presentation by berating the other attorney or maligning the other party. That may sound good to the attorney's client, but truly it's a waste of time and money. I have a courtroom full of people to hear on a given morning, and I really don't have time to waste listening to your personal complaints about the other lawyer. For example, if asking for temporary support, the attorney should be prepared to tell me what his or her client's needs are. How much income does he or she have? How much income does the other party have? How have bills been paid in the past? As sometimes happens, the parties are living beyond their means. Thus, the attorney must be prepared to propose a priority of payment, remembering that if the parties have separated, or maybe they need to, the expenses are going to be more now than they were before. I often tell lawyers, you need to come up with a plan to pay the necessary bills until we can get these parties divorced. I really shouldn't have to tell lawyers that. Winging it on motion day makes the lawyer look unprepared. Think about what it is you want from the court. Talk to the other attorney. Now, we have a requirement that you seek concurrence with the other side before you even file your motion. And then outline your presentation. Be concise. Assume that the judge has read your motion because the judge has read your motion. Simply summarize pertinent facts and make your request for relief. In responding to a motion, the attorney should indicate factual disputes and argue that the relief is not warranted, and tell me why. If an evidentiary hearing is required to resolve disputed facts, say so at the outset. Don't spend needless time arguing for something I cannot grant without a hearing. Know the rules. If you are relying on a rule or a case, have a copy with you and cite it correctly. And also, this is my biggest pet peeve. Please proofread. That may sound trite, maybe heard it since first grade. The second part of proofread is do not blame your secretary. I often hear from lawyers, oh, I didn't know that was there. My secretary must have made a mistake. No, you made a mistake because you didn't proofread. I can't emphasize enough how foolish an attorney will look if the pleadings presented or the order or judgment provided to the court has obvious mistakes, such as the wrong number of children, misspelling of the names of the parties, and so on. One judgment was presented to me in a divorce case, and it contained a provision to change the name of the plaintiff to Mary Smith. The only problem was the plaintiff was the husband. I asked him if he wanted his name changed, and he said no, and the attorney was very embarrassed. One final point. Michigan has a family court statute which requires that cases involving the same parties be assigned to the same judge. Thus, if a couple files for divorce, seeks guardianship for a child, and is charged in a child protective proceeding, the one family, one judge rule will apply. Now, I would just point out that family court is not structured the same in every jurisdiction, depending on the number of judges they have and the local legal culture, so it may be different. And it is different in Wayne County than it is in Oakland. But we have what we call a unified family court, which means our family court judges hear all of the cases that are assigned to the family division. They are divided up. Now, this is a good thing in some aspects because the judge knows all about the parties and the children. But this is also a bad thing because the judge knows all about the parties and the children. And after, I was trying to figure out, I think this is my 17th year in family court, and I don't intend to leave before I retire. It's been a very, very challenging experience. But the pace of litigation in family court is different than the pace of litigation in criminal courts and in the civil division. So you need to, if you're going to practice in a particular jurisdiction, you need to go find out what those particular judges require of you. They may have special rules. We all have local court rules from jurisdiction to jurisdiction. You need to check those and make sure that you're compliant with whatever the rules are that apply to the family court case that you are filing. And I would also mention that unlike other states, we have something called the friend of the court. And when people ask me about that, I always say the friend of the court is a person and a place. So there is a person called the friend of the court who's in charge, and there is a big office that is made up of lots of referees, support specialists, and others that help the family court determine child support, investigate modifications of custody and parenting time, and so they do many, many provide much assistance to us. So I don't know that we could get along without them, but we don't have the same structure as other states do. So I know some of you will often practice in other states. It's important for you to understand the structure, the court structure in that particular jurisdiction. I would now like to turn the program over to Dean Googasian to give you the nuances and important aspects of practicing in the civil litigation era.
Thank you very much, Coach Young. It is an absolute privilege to be here, to be back at Wayne State University Law School. I'll get to the topic in a minute, but I do want to say that from my perspective, attending Wayne State University Law School was absolutely the best decision I could have made for practicing law here in Michigan. The degree works outside the state as well, but Wayne has such an incredible alumni network and such a good reputation here that you're doing yourselves well by attending law school here. Professor Sedler, thank you very much for inviting me and allowing me to be here today. I see Professor Henning in the back. Thank you very much for not heckling. So my name is Dean Googasian, and all I do is civil trial work. I represent predominantly plaintiffs in consumer class actions and personal injury cases for the most part. So a lot of what I do is what Goodman Cohen did many years ago. He and my father were friends, and I'm privileged to be here at a terrific function sponsored in his honor. And Judge Young is absolutely correct that the vast majority of civil cases do not go to a jury trial. Most don't even go to a bench trial. Some go to arbitration. Most get resolved along the way. And so from my perspective, if most all of the cases are going to get resolved by somebody other than a jury, part of what I need to be doing for my civil clients is to try to figure out who, in the immortal words of President Bush, who the decider is in terms of how the case is going to be resolved. Sometimes that's a judge on a motion. Some of my cases require expert witnesses, and without an expert witness, I don't have a case. So a major hurdle in some of those cases is a motion by the defense to strike my experts, because without the experts, my case gets dismissed. Sometimes it's a question of law. Most often, the cases get resolved. They get settled. And so the question in that situation is, well, who's the decider? Who's going to make the determination about whether this case is going to get settled or not? And what is their motivation? What do they need? Sometimes the people who decide that the case is going to be settled are the clients, and really only the clients. And of course, it's always the client's decision. But there are situations where there are insurance adjusters that are involved, where the client would just assume the case go away, but the insurance adjuster is the one making the determination whether the case will settle at a particular level. Sometimes there's a corporate representative. And even though it's a civil case and it's almost universally about money, there are times when the motivation, as Judge Joan mentioned in the family court, there are a lot of emotions that go in. Well, in civil litigation, the same thing is true. And so, as an advocate, part of what we're trying to do is to figure out what the motivations are. If we're going to settle this case, who's making that decision, and what do they need to see and hear? Sometimes it's as simple as going to opposing counsel and saying, what do we need to do to settle this case? If you get a straight answer, maybe you won't. But figuring those things out is essential in coming up with a successful resolution early on. Now, in the civil arena, our cases start with the filing of a complaint. And the beginning of that process is meeting with a client, finding out what happened to them, and figuring out or knowing whether they actually have a case. And if they have a case, whether it's one that's worth bringing for the cost of it, for example. Many cases simply cannot economically be prosecuted on the civil side. In my world, the parties pay the fees sometimes, but also in my case, we handle cases on what's called a contingent fee basis, which means I don't get paid unless I win, one way or the other. So from my perspective, I have to be very careful what we take on, because once we take it on, key at the beginning is to make sure you know what you're getting into. Once your complaint is filed, typically the process of discovery begins. And there are two different types of discovery in civil cases and probably in all cases. One is the formal discovery that you learn about in civil procedure. Your depositions, your interrogatories, your request to admit, document requests, the formal gathering of facts and information. But there's also the informal discovery that sometimes we get away from, but is, in my opinion, essential to really prosecuting your case well. And the informal discovery is getting up from behind your desk, getting out from behind the computer, go and meet the people who are involved to the extent you can. If there are witnesses, go talk to the witnesses. If there's an accident scene, go to the accident scene. If there's a piece of equipment that's involved or a computer program, there is no substitute for going out, getting your hands dirty, and seeing firsthand where things happen and what happened. And if most everything settles, and most everything doesn't go to a jury trial, then rather than waiting until I'm standing in front of the jury to lay out my evidence and prove my case, I'm going to want to be developing that evidence and letting the other side know about it to a certain extent all along the way. Because the stronger my opponents believe my case to be, and the stronger that I can make my case, the more likely it is that it's going to resolve well for my folks. There are, in my experience, opinion, whatever you want to call it, a bunch of different ways to compare cases. The best way to have a case that settles and resolves well for your clients is to prepare it for trial, even though the likelihood of a jury trial is very low, less than 5% perhaps. If you prepare the case for trial, and I'll explain what that means, but if you prepare the case for trial, you have a much better chance at resolving it successfully. When I say prepare the case for trial, you can prepare a case for settlement. File a case, throw some facts up there, don't do a whole bunch of work, throw out some interrogatories that you cut and paste from whatever the last case was that you had that was remotely similar. I can't tell you how many times in an injury case, I don't care what the injury is, I get the same set of interrogatories from the other side that nobody bothered to look at. They just cut and paste them, send them along. Most of them don't have anything to do with what's going on. That's okay, if that's how you want to prepare the case. But that's kind of preparing the case for settlement. You don't really think you're ever going to go to trial, so you don't do all the work you have to. Preparing the case for trial means sitting down at the beginning and figuring out exactly what facts that you need to prove your case. If you have to take it to a jury or in front of the judge on a motion for summary judgment and the federal court a motion for summary disposition. And once you know what those facts are, figuring out how you're going to get them. And then actually going and doing it. If you can come up with a sound discovery and gather your facts and prepare your case for trial, when trial comes, you won't win. Maybe the other side will, maybe the other side won't. But you will be ready to go. So when you're sitting with Judge Young or whoever happens to be your judge in the pretrial conference on the eve of picking the jury, you're confident because you know you've done the work. One of the things that Judge Young mentioned that rang true for me was the variation in the presentations that get made in court, whether it's in family court or criminal case or civil case. I had the privilege, after graduating from Wayne, of clerking for Justice Marilyn Kelly, who you are privileged to have as a professor here at the school. And even at the Michigan Supreme Court level, the difference in quality, the lack of proofreading, was astounding in some of the cases. Some of them, the quality was incredible, and you were impressed with the ability of the lawyers. Others, you couldn't believe somebody would put their name on that and file. The same is true if you walk into any courtroom. And I encourage those of you who are in law school now County's civil motion call is Monday mornings. Oakland's is Wednesday mornings. Wayne County's is Friday mornings. If you have a free morning, one of those mornings, pick a judge, go down to the court, go through security, sit in the back and watch, and you'll be stunned. Some of the people are so incredibly prepared and so capable you can't believe it. And others look like they just walked in having seen the file for the first time. And that's not lost on the judge, I guarantee you. And to follow up with another point that Judge Young made, if I'm walking in to argue a motion and I want the judge to do something, within the first 60 seconds, I'm going to tell the judge who I am, who I represent, what my case is about, the nature of my motion, what I want the judge to do and why. You'll be amazed at how many times when you go to argue, you don't even get 60 seconds in before the judge is interrupted. But those basic things, I think, are appreciated by the bench, and they help you win your motion or whatever the argument is. In terms of getting things resolved, if most everything is going to settle, if most everything isn't going to a jury trial, one of the fundamentals in the practice of law is maintaining an appropriate relationship with your opposing counsel. There are those in the practice of law today who believe that you have to be nasty, you have to fight everything, you have to say horrible things about the opposing lawyer or the opposing client in your motions in front of the judge. I would encourage all of you, if you haven't already, to go to the United States District Court Eastern District of Michigan website, hold down the civility principles, read them, and if you're going to practice in the federal court, you have to, but live by them. They're very simple. Be courteous. Don't say anything bad about somebody unless it's warranted, and even if it's true, think hard before you do it. You're not doing yourself any favors most times. If you reach an agreement with somebody that's a handshake, document it with a simple email, and you'll cut out the squabbling later about what was agreed to. Be fair with opposing counsel, and be fair with the court. And those things will go a long way to aiding in resolving cases when most of them don't end up getting resolved by 6 or 12 of your fellow citizens.
I'm going to hear from the side of the criminal side. Moneka.
Good afternoon. I want to thank Professor Settler, who was my teacher. Professor Henning over there also was my teacher.
I have to go teach criminal law.
Okay. And I thank Joan for inviting me. It's a great opportunity to come back and give back because when I was here, I came as a much more mature student. And in my experience, it was a very cutthroat type. You were on your own. But as I became a night student, the dynamics changed, and I had excellent professors that prepared me. That is one of the things that Wayne State is really known for, and that is preparing you for the practice of law. It is one thing to be in the theory, it's another thing to practice. In criminal law, you're in a much different environment because in criminal law, it's between you and a prosecutor. The prosecutor has already an advantage over you because they have all the evidence, and you're trying to get it. You have a client who is scared, upset, angry, many emotions, and you're trying to figure out what the heck is going on and how best you can advocate for that client. In a criminal case, you're going to begin in the district court. Unlike in a civil case, you're starting at the circuit. We start in a district court. When I first began to practice, I thought, okay, my client's in jail, I gotta go see my client. Experience tells me that's the last thing I want to do. I want to see the evidence. Because if I go talk to my client, I guarantee you, I got to have a second conversation about what the evidence is telling me. Because my client is not going to tell me the truth. The client is going to tell me what he thinks is going to get him off, which is not going to help me advocate. So now I never see the client first. I go see the evidence first. I want to see that discovery. I want to see what's out there. Then I want to have a conversation with my client, and I have what we call coming to Jesus meetings with my client. Because oftentimes we need that because they're not being real and honest about what they've done because they're in a world of trouble. So you've got to be able to take control. One of the things that I've developed my reputation on is handling the difficult client. You heard that I'm the minister, I'm the social worker, I'm the counselor. So I come in and I'm very aggressive with my client, but I'm very straightforward. I'm not playing games, I'm not guaranteeing. I'm telling him where he's at and where we need to go and what I think I can do realistically. Many things about the criminal side is developing relationships. You've got to have relationship with the prosecutor. You see some attorneys that they say, I'm going to fight, and they're coming in and they're nasty. Well, now they can't get a deal from the prosecutor, and something that can't get tried, and now your client has ended up in a worse situation just because you don't know how to be civil to the prosecutor. The prosecutor is not your enemy. You're on opposing sides, but you're trying to resolve the case, and you're trying to advocate for your client and minimize his or her exposure to prison, because that's what they're scared of, is prison. Anything less than that, you're not doing your job. So I come in and I'm trying to look at the discovery at the district court. We get the discovery packet. We used to call them pre-exam conferences. Now we have these probable cause hearings. The same thing. But I get the discovery, I'm reading discovery, I'm looking at what the facts are. In each case, there are elements that I know must be met. So I'm trying to see, does that discovery meet the level of the elements of what has been charged? Oftentimes, and I do practice in both Macomb, Wayne, Oakland, and do some federal. Started in federal, actually. Most times, we have cases that are overcharged. And so we're trying to get back to what's reasonable, what is realistic, what should have happened in the case. When I make a decision, when I'm looking at that discovery, I then have a conversation with my client. And at that first initial time, I'm dealing with, do I want to hold, now they call them probable cause hearings, where I'm going to hear the initial testimony of the officers or the victim and determine whether or not a crime was committed and was it committed in the county in which the person is charged. Oftentimes, if I know that I need to resolve this case and if I know the evidence is overwhelming against my client, I don't want to hold that exam. Why do I not want to hold it? Because I want to get in favor with the prosecutor because I'm looking for something from him or her. And a part of whether or not I get it has to do with how hard I make them work. Now, if I think that I'm going to try the case, then I want to hold that preliminary probable cause hearing. I'm sorry, it's been preliminary exam for years, and now this year it's probable cause, so please forgive me. If I think I want to try this case, or if I think that there are elements that need to be flushed out, I want to hold the exam. If I have a difficult client and I'm not being able to reason with that client, I want to hold that exam and let them see what the evidence is against them. There are many reasons why I may want to hold that exam. The older I get, the longer I practice, the more difficult the clients get, the more probable cause hearings I just choose to hold because it's easier. And it allows me to really get at the evidence and then have a different type of conversation with that difficult client. And so we hold the probable cause hearing, and inevitably, sometimes I have been very successful when I've got cases dismissed because there wasn't enough. I have been successful in getting charges dismissed. So only maybe 2 charges go forth instead of 4. So if I think it's overcharged, I want to hold that exam because I might stand a chance of stopping some of the charges right then and there. Part of that, though, is determining who the judge is. Everything in a criminal case has to do with you knowing your judge and you knowing your prosecutor. Every judge does not handle cases the same way. When you get to the circuit court, you're dealing with cob agreement with judges, and that is the judge saying, this is what I'm going to do to your client if I sentence your client. So I need to know my judge and know, does my judge, is he going to give me probation? Is it a judge that's going to say, I'm just cobbing to the guidelines, I'm not promising you anything? I need to know these things, and I know that down at that probable cause hearing. And so I'm assessing all of that when I'm making a decision, do I want to hold the probable cause hearing or not? If I have that hearing and I'm bound over, the next time I'm going to be in the circuit court is going to be arraignment on the charges in the circuit court. At that point, I am actually in pretrial mode because I can actually resolve that case that day if all things line up properly. Sometimes at that particular hearing, I'm meeting now the prosecutor in the circuit court. The prosecutor in the district court is generally not the same unless it is a special case that is assigned to a special unit, like domestic violence cases. They all follow the same prosecutor. Murder charges are going to follow the same prosecutor. CSC cases are going to follow the same prosecutor, for example. Other cases, you're going to deal with two different prosecutors. So when I get to the circuit court, I'm trying to talk to that prosecutor about what I think are the issues in the case and why I think that this prosecutor needs to negotiate with me. I also need to examine what programs are available. If I've got an 18-year-old, then the Home Youthful Trainee Act is available to me, and I can get them out of the case without having a felony on their record. If it's their first drug charge, I have 7411, where I can get them out of the case without having a criminal charge on their record. So I've got to examine what's available to me based upon what the charges are. I'm also looking at the client's criminal history. If this is a habitual fourth offender where he is looking at life, I'm in a different ballgame than if this is a first-time offender. And so I have to address all of that. And in the meantime, I'm dealing with not only most times the client himself, but I'm dealing with their families. The families are upset and they're questioning. And you have to realize that you are entitled, the client is entitled to attorney-client privilege. So sometimes you may have family members asking you questions that you cannot answer because your client has not given you the ability to do so. And you have to learn how to manage that as well, because you don't want to offend, but at the same time you have to have trust between you and your client. And some clients never want their family to know what really is going on. And that becomes a very difficult dance at times. The one thing that you can always say is you have the ability, because the courtroom is open and public, to sit in and hear for yourself what's going on. Many times the client is lying to the family, so the family is getting aggressive because they don't understand what the real truth is. If you give them the ability to sit there and listen, then they begin to have a different perspective about what's going on. You're also trying to deal with a judge who may be favorable to giving you some type of resolution, but you may have a judge that is not going to be favorable. Well, if you know the judge isn't going to be favorable, then you know everything is going to depend upon how you resolve that case with the prosecutor. And that's when you're really going to be pushing to try to get some type of reduction in that case. And so there are many avenues that you have to be examining in terms of whether or not you're resolving it or trying it. There are some cases that, because of the severity of the crime and you're not going to get anything, the best thing you can do is try it. Criminal cases are probably the ones that are tried the most, because there are some things you just must try. And you cannot be afraid of trials. One of the things I remembered here was most people here, when I was going, didn't really want to try a case. Do not get into criminal law if you are really afraid to try a case. You will make your reputation on your ability to try that case. The prosecutor is going to work with you when they know you are not afraid of trying a case, and you will take it to trial, and you need to beat a couple of them a couple times, and that helps too. And all of these things that we don't really talk about really do factor in. Once you have beaten the prosecutor's office, then they're more likely to give you a little bit more respect and a little bit more consideration. So some cases you just need to try to develop a reputation that you're not afraid. I think that I have used up my time, and I'm going to turn it back over to Professor Sedlin.
I hope you noticed one thing, that all of our speakers were prepared, organized, and had a notion of time limits, so as to allow some times for questions. Unlike academics who tend to ramble and ramble, I've learned that when I was litigating, I learned to make my remarks directly and keep them within a time limit. Questions? Yes? Please stand up. Everybody can hear you.
Hi. So my question is more for the practitioners, although I'm of course interested in what the judge has to say too. Some of us here, I assume, will be going out and eventually hanging our own shingle. So I'm particularly interested in civil rights law, which of course falls on the civil side, but incorporates some criminal elements, or criminal procedure. And so the question I have is, when you're starting out, and you mentioned discovery and expert witnesses and so forth, how do you overcome the immense costs of litigation as a young attorney that isn't necessarily with a well-established firm, or basically doesn't have, the financial capital to back the case? Are there ways to get around that aside from just taking cases that don't include extensive discovery?
There are, and there are a couple. One is to ask clients to pay for it. The problem with that is most of the people who are in that position are in the worst position of their lives to be able to fund a litigation that may or may not turn into anything. You have to choose cases that you can handle, and if you can't handle it financially or otherwise, there's nothing wrong with associating with somebody else who does that work. And if you're going to hang out your own shingle, I would strongly recommend it. Doesn't mean you have to pay a money, but find somebody who does what you want to do and talk to them. Somebody who's a mentor, because they'll be able to help you along those paths. And if it's a good case, you'll be able to find somebody who wants to work with you to help share the burden, financial and otherwise, and that's probably the simplest way to do it. There are some, litigation expense outfits out there. I would never use one. Much better alternative.
Thank you.
Well, you want to add anything?
I would just say, partnering with someone is very crucial, but you need to be careful about the character of the person you partner with. If I had to say anything to what he said, is sometimes you can see someone that has a big name that's very popular, but they're not ethical, and you're going to end up losing that case, or you're going to have some problems that you didn't foresee. So you really need to look at the character and the integrity of the person you partner with.
Next. Yes, please go ahead.
The judge had referenced earlier, you were talking about in the divorce cases of sharing experts. And I wanted you to maybe expound a little more on that, because I would see that kind of as a conflict of interest, that expert couldn't justifiably represent my case as effectively if he's also trying to represent the interest of his clients.
Well, one of the things that you want to do is you want to value, let's say we're talking about a privately held business. It's important to value that business for purposes of distribution in the divorce case. But you can spend $20,000 for two experts who may come close to the same number, or you can spend $10,000 and get one expert that you both trust that will come out with maybe the same answer. You don't have to use the same expert. I point that out only because in many divorce cases there simply isn't enough money to buy 2 or 3 different experts. So I urge attorneys to sit down if they can. There are a number of people in each jurisdiction that are known for a specific expertise. And if you trust them, you can work together with the other side to get a value on the business. Because really, as we all mentioned, we're moving towards settlement. So you want to get some numbers in place. And if you can trust one expert, then that's actually the most efficient and cheapest way to go.
Thank you.
Yes.
Well, I'd like to just comment that sometimes you need a source of information to verify if you're in that situation where you're sharing. And one of the sources that I often use, because all my clients are impoverished, is I use university PhD candidates lots of times who have the knowledge and their professor signs off, but they need a certain amount of experience along with their PhD. Where I use it is I do a lot of Social Security work, and sometimes I need neuropsych exams. Those exams cost $800–900. But if I send them to the Wayne Psychology Department, I can get a PhD candidate who can do all the testing. They'll charge $100 for the computer evaluation, And I've got their professor signing off on it as well. So sometimes you can use other sources, either to back up or buttress whatever you need to sway it a little if you're going to share.
I would just recommend a book to you in terms of preparation for trial, and it's a book called The Civil Action. If anybody's read it, it's made into a movie. It was written by a journalist, I believe. It's really a well-documented progression of how the case gets prepared for trial. It's worth reading.
Let me ask a question to the lawyers and the judge. And this is about Delaware. This matter of finding expert witnesses who have the qualifications to testify, and the judge evaluated these people that lawyers produce. Has it been your experience that lawyers are pretty good on producing qualified people?
Well, there's a fairly small pool in the family law area. I don't know if Dean might be able to answer that better, because he was discussing the need for an expert for his case to go forward.
It is presenting expert testimony has become exponentially more difficult in the last 15 or 20 years. I don't know on the whole whether that's a good thing or a bad thing. Certainly there was the feeling that there were some unqualified experts out there, but to get an expert qualified these days in a federal case, for example, the stack of materials that you have to have is 6 inches deep, and it's exceedingly expensive, and you need studies and support and all sorts of things that, from my perspective as a plaintiff's lawyer, really don't matter if you've got an opinion that makes sense, but they're the hoops you have to go through. So it has made it exceedingly more expensive and more difficult. I'm not sure it's increased the quality of the trial.
On the criminal side, there are not a lot of situations that you're going to use an expert. Sometimes we are using polygraph experts because we're trying to do something in the case. And the pool is very tight and small, and we normally, in the criminal environment, we're communicating with each other and we're getting the same experts that we have found to be reliable. So the bigger issue for us is most times the client can't afford an expert, so we've got to get an expert that the judge is going to authorize payment on.
Are there any further questions? Good. I want to thank Judge Young. I want to thank the Sanford, Mr. Googasian. There is nothing better for aspiring lawyers than to hear it from the bench and to hear it from the perspective of the lawyer. I think many of you will come away and say, I learned more about being a lawyer in this presentation than I did in my classroom. And, when I had come and I discussed what we're going to do this year, I said, let's do something for the students. Because my father's concern with oral advocacy extends throughout the litigation, and the very, very important part, maybe even more important than the trials, which are virtually non-existent anymore, is what is the advocacy and the pre-trials practice. So I want to thank you so much, and I want to thank Ida for the suggestion. It's been a wonderful lecture, and we now have to conclude because of the pressure of class. Thank you again.